Hello, hello, hello. Well, this is an unusual day and an unusual time for us, and I do appreciate everybody's patience with the rescheduling. Thank you so much for being here tomorrow. Sure, it's good to see you. I'm hoping I can get a audio check before we get into this, but boy, we got some stuff to talk about and very current is Sarah Boone, as I listed in the description, had her hearing today. Thank you. Sounds good? Good. So far, the internet is cooperating today, and all bars seem to be good, and all things seem to be functioning. Um, Besides me just really trying to wrap my brain around all that we've learned in the last few hours today. Um, we've got plenty to talk about in regards to Sarah Boone. Plenty, plenty. Hey, Quiz. Oh, you can't, Quiz. I know you never hear me. It's okay. I think you might be the only one right now. But thank you. I do actually appreciate your notions on it. I don't know what to call them. Yeah, you've actually got me stumbling now. But anyway, I want to talk about Sarah Boone's hearing today. Let me just bring up hmm, where we're going to start. And I don't intend this to be a very, very long one, but there are quite a few things to go over. And I'll be taking questions from the chat as we go because there was so much in regards to the hearing that just happened. Um, I did link the hearing. Let me just give you the link. I will warn you that some of the audio on this particular hearing is really bad, really bad. Um, yeah, based on two of the defense attorneys were appearing by Zoom, and so did the representative for the JAC. Uh, Unfortunately, Mr. Henderson for the defense had extremely bad audio and feedback, and the judge did what he could to fix that. Even in the beginning of the video, in the courtroom itself, there was a lot of reverb. There was a problem, but the judge really got on it and fixed that right away. This judge in particular is so patient. And as we go through today's update, I think you'll all agree he really is. He really is very patient. Although you can see it sometimes as it gets closer to trial, he is doing his best, in my humble opinion, to balance the needs for a fair and just trial and the actual reinventing of the wheel that could be the opinion of some that the defense is trying to do. Granted, they're coming into it late. But as Judge Kraynick said in a previous hearing, you knew what you were getting into. It was clearly stated we weren't moving anything. You knew what you were getting into. And basically, he's saying, not my problem, yours. My problem is making sure a fair trial happened, and it's been 4.5 years. And we have to be fair to the state, and we have to be fair to the people, and we have to be fair to the victim and the victim's family. They deserve justice also. Contrary to how defense in Sarah Boone, which is their right because they're coming from it differently, it's just not all about them all the time. The judge's job is to balance it. And that became very evident in today's trial because for the first time, not trial, hearing, sorry, misspoke. Uh, Judge Kraynick did a little bit of pushback, which immediately people were out there saying, do you think Judge Kraynick is biased? When it comes to the timeline and throwing anything you can at the wall to see if it will stick 4.5 years later, I don't really call that bias, asking them to fly right, be reasonable. I was really surprised to see some of the comments in regards to Judge Kraynick being biased. He's been as unbiased as he possibly can. And those of you that have been watching the hearings since he took over in January have seen him bend over backwards for this defendant, warned her what would happen if she kept on the path she was on repeatedly. Okay, he did what he could. And even when he made denied her another public defender and she became pro se, went out of his way to assist her in getting what she needed. Even after the prison, the Orange County prison system's attorney, Attorney Chabanel, attended the hearing and said, "We are only obligated to give her pen and paper." They are doing the best that they could to honor the judge's ruling and to get her everything she needed to defend herself. Um, but I just needed to say that because, like, for me, I was just taken aback that people were so quick to jump, and they only had this hearing to say that, and they're disregarding everything previously that had happened. Um, it it just goes to show you. It just goes to show you that some people they'll just tack on to anything, right? So let's go over. Okay, so the reason for today's hearing, and it was actually posted, is we were going to go over several. They were going to go over several of the motions that were pending. We're coming up to the pretrial conference, which is on September 26th, which is the week before the trial start date of October 7th, which jury selection should start on the 7th. Okay. Judge Kraynick had a bit to say about jury selection also, but we'll get to that towards the end. So today's hearing started at around 1:30. It was only a few minutes late, and it was due to the audio and some other issues and some late filings also. It seems that the defense decided to tack on 4 or 5 different motions that were amended last night, and also the state, after one of those motions was read, decided to answer it first thing this morning. So Judge Kraynick did start a few minutes late, and he did say it's because I wanted to read everything before we came in here. I want to get as much done as possible. So granted, a couple of minutes is not a big deal. Welcome, Charlotte. Mm-hmm. I know, Charlotte, I would not want to be this judge. I don't know if I could be as patient as he has been. This man is doing an incredible job for the system, and he's an example, and he should be honored and not ridiculed as he's being on Twitter right now. Like, I think it's ridiculous, but I just had to say my piece. Anyway, the motions that they were going to handle was the motion for the statement of particulars that the defense had filed, because they said that in the indictment, in the charges, the state was being too vague. Okay. Motion for additional discovery was going to be addressed, and that was in regards to procedures in regards to interrogation and interview from the county sheriff's department, and also a copy of the Miranda cards that are used in procedure and protocol in regards to that. That was the second motion for additional discovery. Motion to appoint forensic psychologist. That would have been the addition of a second one, Dr. Brannon. The motion to appoint a crime scene reconstruction death investigator, and that would be Dr. Michael Birkland, and we're going to talk about that in a little bit. Motion for the return of property. Sarah is asking for her cell phone back. Then they were also going to address the motion by the state to strike the defendant's notice of intent to rely on the defense of battered spouse syndrome. Now, we talked about this in the last update, and I did give you some regulations to look at on that with Florida. They are actually adding this in as a reason for a defendant to be in a certain state of mind that she may not have acted as reasonable as another person would. Okay. And there was a lot about that. Hello there, dog. Hello, Teresa. Listen, and also the amended notice to intent to rely on a defense of battered spouse syndrome, which the state again applied to, because there was a response by the defense. Okay, so let's just get right down to how these things went forward. Okay, so the first thing that they, first of all, courtroom, I just want to let you know these are the assistants of James Owen, the defense attorney, sitting there. That is not the main prosecutor, Mr. Cacciatore, sitting over there. He was available by Zoom because he didn't want any shenanigans. So a question did come up. And the judge said if he can hear us and he's available, would he pop in and answer this? And Cacciatore did, like, hit the screen immediately and answered a very direct question so that there was no delay. I give the state credit for that. The state is doing what they can to stay on and work with Judge Kraynick to keep this on track. Even though some of the things that are coming up that we're going to talk about are actually a hindrance to the state, and they could have a problem all the way up to the date of trial on October 7th. Oh, we're going to get to that. But I wanted to let you know that they had Sarah sitting right at the defense table like she would be. She is handcuffed again. She is in regular street clothes. And she spent a lot of time chatting back and forth to these two young, either assistant attorneys and or paralegals from the office of James Owen. The second and third chairs, Dr. Attorney Kevin Beck, who is the third, the actually second. He's actually zooming in from New Mexico. He's not even in the state of Florida. Okay, and then there was Mr. Henderson, who also came in by Zoom, even though he is in Florida. I will say that Mr. Henderson himself does have some actual credibility issues that have come up to light, even though no charges were put against him. But it's not my place to decide who Sarah Boone decides to have as an attorney. I think at the end of this, I do have a little bit to say about some of the things I saw in this hearing, and I have seen in the in interviews of Mr. Owens that I am wondering. I'm wondering why they decided to sign on, but whatever the reason is, I will say this. They're definitely doing what they can, pulling out all the stops to give Sarah a good defense. They do believe a lot of what they believe, everything Sarah's telling them, and they are trying to put a defense around it. I could say that. But some of the things, there's been some pushback, and rightly so. I do think that they have a time crunch and they're in a very difficult position, and I understand why they're trying what they're trying. But I also understand the rights of the state to push back, and also the rights of the judge. It's all up to him on whether he thinks it's reasonable or not. And I think that's where some of the bias might be coming in. People are saying because he's pushing back on the defense and she finally got an attorney, like, they should, like, no, he's already said he's not giving this another year. She's had the time she's had. The evidence is what it is. I mean, she's had 9 attorneys. Okay. And one statement that was made repeatedly by the state in their arguments was this trial isn't against Mr. Owens. The defendant is Sarah Boone. And Sarah Boone's been here for 4.5 years with representation the whole time. And that resonated with me because I'm like, yes, it's about time somebody kept underlining that, because a lot of Mr. Owens' arguments during this hearing are based on how inconvenient everything is for him and what he's trying to accomplish. And I get that because it's true. He's got a huge hill to climb. Huge. But as Judge Kraynick keeps reminding him, you chose to take it on. Those facts were clearly laid out. That was your decision. It was in my ruling. I'm not moving the trial date. And he has no intention of moving it. All right. On to the motions. First one, motion on particulars. 2 defense motion, an amended one and another one on particulars. That the defense was claiming that in the indictment and the charges were not clear enough for Sarah to understand exactly what she was being charged with, so they could not actually defend against it. But Judge Kraynick kind of agreed with the prosecution that in the original statement and the indictment included the actual legal requirement by statute to the letter that the date, time, and place of charges in the cited charges sufficiently indicate the crime committed by defendant in charge. She's charged with murder too. She's charged with an indifference to life. That through her actions or inactions, and there's the clause, or inactions, quote unquote, underline it like 3 or 4 times here, caused the death of Jorge. They do not need to say she used a weapon. They do not to lay out step by step what she did. Okay, the evidence clearly states it. The state reminded Mr. Owens that he is in possession of all the evidence that they plan on presenting, and they know exactly, more than most defendants, exactly what will be said in court. And, well, Owens pushed back. But how do they say she did it? Like, how am I supposed to go against that if I don't know? It basically, to me, and I'm not a lawyer, but it really sounded a bit whingy. It sounded like Owens wants everything he can done for him ahead of time so he knows what to do. He wants to cut every corner possible. Okay, he basically, I mean, I his argument made it sound like he wasn't going to get satisfied about what they were presenting unless they pre-recorded their opening statements and laid out their case and handed it to him ahead of time. And we all know that doesn't happen. We all know that a motion on particulars, okay, if you do a little bit of the research, is not even required, and it's only used in extenuating cases where, as the state and actually Judge Kraynick brought up himself, this is for when there is multiple complications in the case, like there's more than one victim, it happened in a crowd. What is it when there's more than one person involved that you say this particular defendant did? But in this case, it's very clear what they're saying that she did. There is no doubt what they're saying what she did. It should be easy enough for the defense to see that. It, in my humble opinion, and I could be wrong, this was step one in Mr. Owens after he was refused a continuance in getting the trial delayed by trying to get the state to jump through hoops to provide things for them and then claim that they're the reason that things need to be delayed because he clearly got the message from Judge Kraynick that the defense coming up with anything on their favor on why it should be continued was not going to be accepted based on the particulars of the case, the warning that it wouldn't be moved. You chose to take this on. Sarah knows the deal. Not my problem that you came on last minute. And that's not going to be, and because he put it in his order, the hiring of an attorney would not be sufficient extraordinary circumstance to continue this case any further. The dates are the dates. He put it in black and white, which was available for Mr. Owens and his huge team that he's trying to put together to do this in advance to read, was available. He should have got the note. Okay. He should have got the message. Okay. But the state said, they're not even required to do anything more than this. They gave him a motion of particulars, which was basically the indictments just laid out, okay, in the charges. And anyway, long story short, Judge Kraynick denied the motion for the state having to provide any additional information or extenuating in regards to the motion of particulars than what they already did. In other words, you're going to just have to accept what they gave you. That's an answer to your motion. Denied. Do not amend. Nope. Over. Put it to rest. Then they moved on to the motions on additional discovery. Now here, Judge Kraynick really started to get into law because it appeared he was quite confused as to why they need this. Because these two motions, one is for the sheriff's department to provide their actual protocol and instructions to detectives and everybody else in regards to interrogation procedures. It's like they wanted the manual, okay? And the second motion for additional discovery was in regards to the Miranda card in the reading of Miranda rights and whatever the sheriff's department, not the state, had in regards to the copy of it or what they're instructed to do. Judge asks, why do you need that? Because Basically, the state said in their answer back, they said they slapped the wrist of Mr. Owens and Sarah Boone and said, "That's not our job. You contact the sheriff's department yourself for this information. That's part of the defense's requirement. We don't plan on presenting it. It's not part of discovery. We don't need it. We know what it is. If you need it for your defense, you go get it. You have It's public information that is available to you through the sheriff's department. Go get it. We're not holding anything back from you. We don't have it. We're not requesting it. If you want it, go get it." Basically, the judge is like, "Well, what's wrong with that? Like, you could require it." Well, Mr. Owens presents an argument, and here's where, well, little red flags started to pop up to me, because Mr. Owens said the reason he was requesting it from the state is because he's in a long line of requests through public information with the sheriff's department, and that it may not come in time, and he's just trying to cut the red tape, and he knows that the state department, that the state only has to make a phone call to get it, and he would appreciate it if they just did that so he could have it quicker. Like, and he just, that was it. Like, he wants them to do their job, just as the state suspected and answered. Mr. Owens was expecting the prosecution to do his job for him, and to take into light that poor Mr. Owens is under a time constraint. And I understand that's very difficult for Mr. Owens and the defense team. I get that. But you don't really think you're going to fight? You had the time to file this motion. Send your clerk down there. Put some effort in. Put some expense. No, he would take the time to file a motion and try to make it somebody else's problem just to be told no, and then come back and ask the judge to decide on it anyway. And the judge is like, "No, no." So Mr. Owens then said, "Well, so Judge Kraynick pushed back, and he says, like, "Well, why do you need it anyway?" And he's like, "Well, we feel there was a violation of Sarah Boone's rights. We feel she was coerced. We feel she was a read Miranda right. We feel that all this." And the judge is like, "But you have the interview." As the state had said, you already have the interview. You have whatever you need if you're going to go for a violation of rights and try to get the interview evidence kicked out. You have the interview. File your motions based on the fact of the interview. "Well, we don't know if they violated it." I say, "Well, you're watching the interview." He says, "Yes, but we're going by what Sarah said." Apparently, he hasn't watched all the hours of video, because he kept repeating that he's going by Sarah's statements of how she felt. Okay. And apparently, there was one line at the end of the Miranda that may have been left off that says, "Would you like to continue this interview?" or some wording that he says in particular he didn't hear word for word. And Judge Kraynick quickly reminded him that in order to file motions on the violations of her rights and to get the evidence dismissed, he does not need the sheriff's department's protocol. All he needs is the interview, the video of the interview and the interrogation and the reading of the rights. It's all on tape and it's all been submitted, And he kept saying, "Yes, but we just want to look for the detail." He goes, "That's not how a violation of someone's rights gets stated in a motion. It's the act. What is the violation you are claiming?" Like, he really pressed him. "What are you saying was done?" He said, "You don't need it to motion or defend the evidence. You have the video." Well, Owen said, "Well, you need to look at the video, Judge." The judge says, I've not seen the video." He said, "But anything that you need would be in there, as the state said. Like, if there was a violation during the process of the interview, you have a recording of the interview, the whole thing. Use that. Nobody's denying you information." In other words, he was saying, it's ridiculous for you to state to this court that we are denying you access to information to file a motion on her rights being violated. It was pretty evident to me that actually annoyed Judge Kraynick, that they're going to claim a violation of rights and actually a delay by everybody improving it, as if there's some kind of conspiracy. He shut it down quick. He did. And he pushed it right back on Owens where it belongs. If that is your case, that her rights were violated, file the motion that says so. and use the actual evidence to file that motion. You do not need this extra. And if you do want it, which is your right, go get it. But the state has no obligation to you to provide anything further than the actual video that they did and the statements of all of the detectives involved as they did. And remember, there was a whole big Brady thing where this particular main detective was actually uh investigated for some kind of misstatement or writing up of something, and she was actually cleared, and the state went out of their way to disclose all of that to everyone as is required by law. It's not like they did them a favor. That's required, and they did it, and they followed it. Okay, and that's all been cleared up. But apparently they he wanted some help. Apparently having three attorneys and these assistants and a private investigator isn't enough for this defense team. They want the state to do some of the work for them. I realize that's a little snarky. Can't help it. It was very frustrating to listen to. It really was. Now, before I go on to the next one, let me just check the chat. Hello, Liam. Nice to see you. Hey, Turtle Moves. I keep coming back to the thought that Sarah would very likely be out of prison by now or close if she had just showed contrition and taken a plea deal. She probably would have. Yes. They did think that there was some hullabaloo going on with her changing her statement and all, and we're going to get back to that because there's a lot to say about that interview. There's a lot that she admitted in that. I recommend it's out, it's public. I think everybody needs to watch it. Okay. I would really like to have another discussion on if you think there were any violations to her rights during that interview. Apparently, she's claiming that she never would have said anything that she said. When I watch it, I see Sarah actually trying to convince them of a story. I don't see them leading her into the story. Okay, but we'll get to that. But I really hope that everybody will find those. They are listed in the other room. They're listed on many of my other videos, and I do believe I even listed some of the better ones with good quality audio in the playlist and from other YouTubers. Okay. I feel like my self-incriminating speech may incriminate me. It needs to be stricken as it makes me feel bad. Exactly. This is an attempt to get the whole interrogation out because as we're going to get to it at the end, that whole interview and all of her statements don't match the defense that they're going to come up with for trial. And this is a way for the jury not to hear it. Yep. I agree, Charla. She is her own worst enemy. She really is. It's good to see you, dog. And Teresa, I'm glad you stopped by. I hope you catch the rest of it later. And Turtle Moves, it's always good to see here. I hope the earlier time frames are going to work for some of you that watch me from other countries. All right. If you're ready, let's go on to the next one. So anyway, as it says there in big red letters, of course, Judge Kraynick denied in support of the state's pushback that they don't need this discovery. If they want it, they can go get it. And that was the end of that. After a long discussion about violation of rights, there is no motion on. Nor is Mr. Owens being very clear on what right was amended. Now, there is the right to not self-incriminate. She could have pled the fifth. They didn't make her talk. Okay. Yeah. Well, I want to see what was going on here. Everyone knows that during an investigation, they are allowed to make leading questions. They are allowed to withhold information. Okay. They are. Yes, they are. Motion on the experts. Okay. This is in regards to Julie Harper. Okay. The forensic psychologist, the one that's going to be actually listed as being the main expert for the battered spouse syndrome that the defense wants to put forward. There's a lot to be said about that at the end of this hearing. But anyway, we're just talking about the clinical psychologists, forensic psychologists, and all of that. There were several motions and amendments for fees. They were approved. Dr. Michael Berklin was approved as the clinic crime scene investigator, and death reevaluator. And I normally don't do this. Look into the expert witnesses and or the attorneys, but a lot has come up. And when it comes to Dr. Michael Berkland, although the JAC has approved him, and he is like a witness for hire. He's an expert witness for hire. He's been in Florida since 1994 when he became the forensic psychologist doing autopsies. I just want to say that there is a lot to be said about his career in Florida before when he was working for the state. There is an article out that kind of lays it all out. I'm going to give you access to the article, and then I'm not really going to weigh in too much. I would like you guys to read it because it does give concern. I would just like to state that Dr. Michael Berkland has had his medical license suspended and removed in other states, and that he was fired from his position with the state of Florida when he was the forensic psychologist working for the state, based on getting his position under false pretenses in actually performance issues. Um, he no longer works for the state, but he is with his title a expert that's out there. Um, I don't know how much, if any of that is going to be presented to a jury. I actually doubt it. So it's kind of moot, but I know that some of you really do like to get the whole picture, and I don't want to appear biased or against this man in any way. I'm not, but it is kind of hard to ignore. It's kind of hard to ignore. Okay. Here is the article I'm referring to by another site. It just came out this May. It goes all the way back to Mr. Berkland, who is the crime scene in recreating investigator and all. And the only reason I'm bringing it up is some of the issues and claims that were made by the state in the past against him pertain to this case. If we're going to use him, if the defense is going to be using him to actually recreate the crime and actually relook at the autopsy, then it's pertinent as far as I'm concerned. Okay. Um, there is a YouTuber by the name of Takesha's Two Cents. She's kind of quirky, funny. She's been doing stuff on Sarah Boone like every day. She gets a lot of information on the video. If you don't want to read the article, is her going over in if you would prefer to look at it that way. Okay. Um. Oh crap! What is this? Sorry about that, guys. The system just completely booted me. I hope you can hear me. Then I'm back. Hopefully back. Okay. Oop. Yeah. I know, Liam. Like, what was that, right? Like, usually it just goes yellow, but in that case, it just kicked me completely. But I'm back, and hopefully, you all just saw like the blank screen for a few seconds. Okay. Yep. Mm. A buffer and a gaslighter being an expert witness for Sarah is perfect symmetry. Uh yes. Unfortunate. A bluffer, yes. Not buffer. Yeah, I get it. Oh, she definitely thought she could bamboozle the cops and use her charms on them to make it all go. Yes, in the investigation, in that interrogation. Hey, Jen. Mm, you saw it before? Yeah, it would be good. I think it is listed in the playlist. If not, like, let me know. I'm gonna go back later and look anyway. Nobody has to let me know. I'm glad you can hear me, Purple. I'm glad it's back. Okay. Hey, Jen, it's good to see you. Oh, I am so glad to see you about. I really am. I want to talk to you. I want to thank you personally for something when we get time. But when you have time, Jen, hit me up. Anyway, this expert, it just needed to be talked about. There was issues in regards to the attorneys. There were some federal law enforcement investigations that could not be filed against Owens, Henderson, and some other man named Day. Another, they were all while they was working in the prosecutor's office as state attorney and assistants, and there was a serious issues that came about. Now, I am not going to provide any articles or anything on that because law enforcement investigations are sealed records, even though they've been redacted and some people are releasing them. I'm very uncomfortable about it. And here's the bottom line. They stated that based on the statute of limitations, 5 charges could not be filed. So it's one thing to know about it through rumor, talk, and gossip, and that it existed. And the fact is, the investigation was credible and it did exist. And that the findings of the investigation were confirmed. Okay. But no charges were pressed. So they both have active law licenses. I can't really um I can't really go against their right to practice law or say what kind of attorneys they are or how good they are at it. I'm just saying there's some credibility issues there. There's some past history there. And now that this other expert that they're going to use comes into light in a bad way. I mean, it's when you read the article, it's going to be pretty hard to ignore. And the reason I'm bringing it up is I'm very curious if the state is going to address it. Because, when they do talk, we've seen it in trial after trial. We have seen the defense or the state go to the expert witness and have them prove their credibility on whether or not they can be an expert witness. Now, that doesn't happen until trial. It's not up to Judge Kraynick to look at this man's history and say anything at this point. He's just like, okay, you need this expert. Fine. If JAC approves it, I'm okay with it. All right. I will say that when JAC was asked in regards to the late filing of adding Dr. Brannon, a different issue, not Dr. Michael Burkhart, Dr. Brannon, another forensic psychologist or a clinical psychologist, the JAC made note, the representative who was Mr. Lake, Christian Lake, he actually made note to tell the judge that this would be the third clinical psychologist approved or forensic psychologist approved. And they don't have no issue as long as they stay within the pricing guidelines. But he wanted him to know the history there. Okay. And he went out of his way to say that. And then so the judge said, well, if they need it and they can do it within the time frame, then why not? Like he approved the adding of the additional psychologist to the list. Okay. And that's going to become part of the issues we're going to talk about towards the end, because there was actually a verbal motion made in the court today at the end that they wanted to discuss that really becomes pertinent in a little, makes me scratch my head. Okay. JAC has also made some filings to the court in regards to all of the costs during the last 4 years and the type of people that were hired. And I think putting that on record was actually a benefit to the defense, because if they had previously hired other experts, why not just call them? They must have done some work if they got paid. And you can use that. You're still part of the defense. You don't have to have been the one that hired them. You can get that record from the other attorney. You can get that record from the source itself. You could cut some legwork by making some phone calls, get your paralegal on it. Okay, Mr. Owen, I'm talking right to you, since, time is over constraint and you keep whinging about it in court and trying to get everybody else to do your work for you. There is a lot of work that was already done. In essence, this is why you can't just use the fact that you're using Julie Harper as a reason to delay that she needs to talk with Sarah Boone, because sorry, sir, back in 2022, she was already on file with multiple visits to her hired by Maurice Padillo. Okay, with that opinion. And at that time, Maurice Padillo decided not to go forward with the battered spouse syndrome. 2 weeks before the trial, he gave notice that he wanted to be removed from the case and had not filed to use the defense. And you need to file 30 days before. So he wasn't intending, by how it appears, to use that as a defense, even though he knew what the expert witness was going to say. And I have opinion on it. I think it's because Sarah's own words. She has to get up there and say what happened because nobody else is witness to anything. They are going to be using interviews from arresting officers in regards to their explosive history of a relationship, but we're going to get into that at the end. Okay, because we there was a motion in regards to battered spouse syndrome being used, and the state is pushing back hard. In Judge Kraynick gathered a lot of information during the hearing on it. We'll get to that. But in regards to these clinical psychologists, Julie Harper was hired all the way back 4 years ago. She's been on board, and that's just evidence right there that you could get this done timely if you would review the record appropriately and find out what experts had been hired. If they've been paid, they've got testimony and work. It would be simple to get the rest of it applied in a lot less costly, and a lot of less time would be wasted. It would fit the timely filing that the judge is trying to keep you in line with. Okay. But anyway, all of the experts were approved. So far, it doesn't look like that's going to delay anything, except for there has been actually no meeting with Sarah from Dr. Brandon as of yet. There's been no depositions. There's been no reports given. The state said they had no objection to the adding of that clinical psychologist as long as they received the information timely in order to be able to object to it into what he was going to be reporting on. And that's status quo. I mean, that's just how it goes. Okay, you can get your experts, but you got to disclose in discovery your evidence and what everything's going to be, and they get to file objections to get it tossed if they want, or at least have full knowledge of what's going to happen in the court, just same as the defense. Okay, and also in regards to Michael Berkland, they do not have any reporting from him either because he hasn't done any work yet. They were waiting for this. In regards to the previous Julie Harper, Michael Berkland, they all that goes back to August when he first mentioned that he wanted to bring them on. Dr. Brandon wasn't approved until today, but he's going to actually allow it on the 17th, which was when it was filed, and for charges if he's done any work. All right. So anyway, that was like approved, right? With JAC. Well, that was good for the defense. Not this one. Motion to return the property. Sarah's been arguing about her cell phone for quite some time. We've heard it in multiple, even in her pro se hearing. She says there's evidence on there that she needs. Okay. The state has repeatedly said it's been available for 4.5 years. You could come in and do a forensic analysis. You could bring your own expert in and copy anything you want. We gave you our dump of the phone of what we're going to be using. We gave it to you, and we gave you the cell phone dump that was done, by the expert that we hired. Okay, we gave you that all that reporting. Sarah says it's inaccurate. She told her attorney there's stuff missing there. There's stuff that I can pull up that will show my defense. Okay, so Attorney Owens filed that he wants the cell phone back. Well, the state says no, there's a procedure. They filed back and said no, we don't have to do that, and here's why. All along, there's been procedure in place, as there is for every defendant in every case in the state of Florida, where if you need to examine the evidence, you can come in. No one is stopping you from bringing your expert in to take a copy of the phone, but we're not giving you the phone. This is evidence we're using in our case. It was actually given to us during the investigation. We're keeping it, and we're not going to allow that. You all can see why they wouldn't, right? Because now custody, chain of custody, they could actually go against actually the information that was actually pulled from it, saying, oh, this, that, or the other thing. No. Once it's in custody and locked up and sealed, that's it. They do have actually provisions where you can come in with your expert and you can take your copies. You can look at the phone. You could touch it. You can examine it. You could do whatever you want. That's all allowed. And you've had plenty of time to do it, but you didn't. Okay. And The judge went through the record and reminded Mr. Owens that there was an expert witness. That was, oh, let me see if I can find his name. I believe the last name was Sawicki. Okay. And he was yep. There was a expert witness in technology, in cell phone expert technology, was actually asked the JAC on May 5th of 2020, and it was approved on August 3rd of 2020. And Mr. Sawicki was pre-approved to go to the state and get that information that Sarah Boone has been saying she needs. But it wasn't done. This is when state attorney Mr. Cacciatore got on the View from his Zoom because Mr. Kraynick, Judge Kraynick rather said, I'm sure the state could answer as to whether that ever happened. Did the expert ever come in and copy the phone? Well, is that part of the discovery that was turned, did they actually come and do that so that they actually have that and perhaps they just don't know about it? But he said, the attorney who was there, the assistant district attorney who was there, and forgive me, I didn't catch his name. I didn't even write it down, but I'll try to correct that later. He actually said, I would not be aware of that particular fact, but perhaps Mr. Cacciatore would. I could check with him. So Ms. Kraynick said, well, if Mr. Cacciatore is listening, and I believe he is, and he's available by Zoom if needed, could you answer that for us? And he popped right up on there with the visual, and he said, I can tell you the expert never did call. No examination of the phone was done at the prosecutor's office by the defense team in 4 years, 20 months. Or 12, 4 years, 20 months. Nope, wasn't done. Was not done. So they said, and in that light, we're not stopping the defense from doing it now. That's what the state said. And so the judge said, well, okay, defense can send an expert to explore that and extrapolate the information. And Judge Kraynick recommended that they contact the previous guy since he was already approved, and contact JAC to just ask them if it was already pre-approved. Can we still use it, or did it expire? To trying to guide him into, you don't have to reinvent the wheel. Let's just try to see if we can use what we have. If you don't have to file a whole new motion and go through this whole process again to get that information. All right. Anyway, so Sarah's not getting your phone. The defense is not getting the phone. But they still have access to do whatever they want with the phone. They just need to send the expert in. Okay. But Sarah's inability to work with her attorneys, 8 of them, is the reason they don't have the information for the phone. I hope we see that there. I'm sure Judge Kraynick does. And he's not letting Attorney Owen use it to delay anything because they had access all along. I have to say, he was so patient. He really was so patient, this man. Okay. Let me just check the chat before we get into this big one. Hey, Juju. Good to see you. Liam, I'm thinking that this is actually in reference to Dr. Michael Berklin. I agree. I think that they would actually try to discredit anything because once you read that article, you see. I just don't know what's allowed. I'll be honest. I have to check precedent on this. I really do. And thanks for the message. I keep forgetting about these. Fantastic stream. Thank you so much, Liam. I appreciate that. Hey, Sean. Good to see you. Meep, meep. I agree, Juju. Sarah says a lot of things. And in that interrogation, I'm sure you agree, she said a lot of incriminating things. Okay. And that's where we're going to get to this very contentious part of the hearing. In regards to the motion to strike, the battered spouse syndrome defense, the state pushed back. They want it stricken. They don't want them to be able to use it because they say it's contradictory to actually Sarah's own statements. And here's the fact that they point out, and they use Wagner to do it. Okay. And Wagner is a case law, which I'm going to give you some links and some stuff too. But I've been looking into it and actually just listening to Judge Kraynick, who actually looked into it before the hearing also. The state is saying because there was no weapon and there was no imminent danger, okay, imminent threat is the key words, okay, which eventually Judge Kraynick keyed in on and put right out there, okay. And this was the most startling part of the hearing today. When I say that, like my head snapped several times during this hearing. Like I was like, huh? I was like Scooby Dooing, like, hmm, hmm, like multiple times. I wish that I had some of you with me to watch it because it was almost comical the positions I was putting my head in my face in, like I could not believe. And yes, I was talking to the screen a lot. All right. But basically, George Kraynick is trying to get down to why are you trying to put this defense forward, and let's make sure that everything is followed in regards to regulation, because the state's biggest issue is that, first of all, the sufficiency of the notice in motion, because what you have to do is say what things happened that correlate to this. What actual incident in regards to the charges happened that correlate to why battered spouse syndrome would be a defense? In other words, it's usually self-defense, credible threat, you know, in the middle of an argument, whatever. Sarah's own statements, as was repeated in the court by the state, and that we've all seen in the interrogation, and that Judge Kraynick also, without actually watching the interrogation, was listening to the state's response, that Sarah herself said it was an accident. It was a great day. No one laid hands on each other. I was very happy. I can't believe this happened. Things have been good. Okay. These are Sarah's words. She's the one saying it's an accident. The state's going by what she said. She keeps claiming an accident, but then there's a video of her sitting on the couch taunting him as he tells her he can't breathe. Can someone explain to me how Sarah can say she felt imminent threat? Her life was in danger while they were playing a game of hide and seek? Her words. She said they were playing hide and seek. She said things were good. They painted, they crafted, they did puzzles, they were drinking. The state also said that the prosecution asking them for every single offense that they know of that George had done was unrealistic. They could get those files, but all they prove is that they had a contentious relationship. Sarah already admitted they did, and that Sarah was a contributor to those offenses. Okay, and that should they pursue with this, then, well, alcohol as a play will be coming up, and that Sarah herself's own words will have to answer to these actual allegations, should they bring them in. See, Sarah wants to be able to bring in George's bad behavior in regards to abuse, but it's not saying whether or not she will be testifying to that, because the state has every right to come back with that at her. They're saying that the only way she could do battered spouse syndrome is she takes the stand herself to tell the jury about those incidences. They can't be entered under this defense any other way, because it's not actually a defense as came out in the trial. It is a way to support a defense. A defense of, hold on, are y'all sitting down? Self-defense. The only way to bring this in is to say as to the reason why she acted the way she did in self-defense, thinking she was in imminent threat or danger. Now, that was shocking to me, because Judge Kraynick said right to Mr. Owens, I have never heard this self-defense. You have never said that. And Owens, in front of everybody, said, "We are going to claim self-defense." Sarah's own words the whole time have been, "It was an accident. I didn't know. I was surprised. I thought he would get himself out. We had a good day. Nothing was going on. We never touched each other. It was a good day." Now, with only Sarah being the one who could testify what happened to that night, they're going to claim self defense. I'm shocked. I'm shocked. Can you see why I had a Scooby Doo moment? Are you with me? Uh, are you with me? Did I lose you? She does. She says all the things, all the things. I don't. That I agree or that the state, what? Call me cuckoo, but if someone is zipped in a suitcase, is there imminent danger? Not that I'm aware of. An imminent threat. Now, she could say that past history made her feel that there could be, but she was free to get off that couch and leave. He was zipped in a suitcase. He said he couldn't breathe. Now, it might be defense, you know, her getting a clinical psychiatrist to come in and just say that she wasn't thinking clearly because she has these mental health issues like PTSD or something like that based on prior events, and that she thought if she let him out, he would attack her. And that's why she left him in there as a reason as to why she left him in there. Okay. But is that really self defense? Is that really imminent danger? You know? I know, you know? You hear me? Good. But tell me, I mean, hopefully, like I'm Scooby Dooing on this self defense thing because that's a whole nother. First of all, Owens, the state is using Wagner, to say that, well, it's not sufficient notice because they can't prove with anything other than Sarah's testimony, and she's not filing an affidavit, or nor is there an affidavit on file as to all of these events that would have caused her feeling the threat. Okay. So there's not, that has to be in the way the law is written in Florida. That has to be when you file for this motion. There has to be that. And then there is a psychiatrist component that proves it, that yes, based on their statements and everything, that's like, but that's not even on file. Sarah's words aren't even on file. As a matter of fact, Sarah's words are on file to exactly the opposite. And that's the state's point when they say sufficiency of notice in regards to meeting the points of notice that are required 30 days before the trial. You didn't meet the requirements of notice. Yes, you gave us notice, but it was insufficient to meet the requirement. Okay. Then there's also for the judge to decide if it's even applicable in this case, which it was also brought up by the state. And that's what Wagner, when they kept talking in the hearing, and I recommend that you do listen to the hearing because, like, I do pose the question to you: how many Scooby Doo moments did you get when you watched that hearing? Because there was so much, too much for me to even cover in like one. Even though I'm dedicating this all to this hearing, there's just not enough time to go over every Scooby Doo moment I had. And when I mean Scooby Doo, I mean like the whoa and the and the huh and the like row, all of it, like so many, you know. Self defense in this case is bullshit. Drunk, dumb is more like it. You know what? Exactly. And the state tried to actually put a warning out there to I took it as a warning or a notice or like, hey, just look at this, as that those actions of the alcoholism of actually Sarah Boone would come into play, and actually her admitting to laying hands on him in several of these incidences that they're bringing these officers through forward to attest to. I'm sure the state, given enough time, could bring many more. Okay. There were several. Okay. And then the defense said that they were going to bring Brian Boone in to testify for Sarah Boone in regards to what was happening with George. And the state just pushed back. Well, according to our conversation with Mr. Boone, he said that Sarah had actually scratched and hurt him, and that there were many times he had to constrain her. That Sarah, when drinking, was quite physical herself. And he is not an abuser, nor does he have any charges on him ever. Okay. And he actually, in his conversations with law enforcement, gave a different picture that Sarah could be quite aggressive and physical, and that he suffered injury from Sarah. And yet the defense is planning on bringing this man in to testify for her. Call me crazy, but that just seemed unpredictable and not exactly stable for the defense, because it could go either way. The state could obviously pick apart anything that Brian Boone says as far as the affidavit he already gave. And Sarah just might be delusional enough to think, well, he married me and he's good to me and we have a child together. He's going to be on my side no matter what. He knows George was horrible. But Brian's testimony so far, from what we've seen, has always been, yes, they were in a contentious relationship. They were both bad. I was like a single parent because she was unreliable based on the drinking and the arguments and everything. But never does he say it's all on George. He says they, the situation, them. He's not there going, oh, poor Sarah. I've never heard him say that, you know. I still think if she had said crap, I passed out, I didn't realize he was in danger, she would be half done with her sentence by now. Exactly. That came up in the beginning. Had there been a plea deal, and let's be clear, just recently, the attorney, Mr. Owens, took to the mic and gave a statement out there in public, which was corroborated briefly by the state, that before he took on this case, he went to the state with Sarah's permission and tried to garner a plea deal. But I don't think she'll cop to manslaughter. I don't. I don't think at this point, after 4 years, even the new attorney knew that her best opportunity was to make a plea, and went to them and tried to negotiate. That came right out of his mouth before he took the case. And he talked about it, right when he said that Sarah would be paying him one way or another, when he told the judge he was taking it without pay. Then after he made that statement, I think it was on on court TV, he, in a phone interview, he actually said that she would be paying, there would be some kind of payment sooner, after. But for now, nothing. And now he's saying he actually filed that there would never be any payment with the court. So I think he took that back. But to me, that was another red flag of sketchy, shady. What you doing, dude? I don't know. I don't know. Justice. I don't think justice is the only thought here. That's all I'm gonna say. Oh, Sarah is never going to admit to doing anything dumb. Exactly. Yep. Exactly. And I do realize, Juju, he did divorce her, but is that even? I mean, that could have been for any reason, but apparently she just was not good. He said she changed. He said she wasn't the same person that he married. He said the alcoholism became a problem. He was quite honest in his interview. He didn't believe she did drugs. He just believed that he did not believe she could be controlled. It was he didn't think that George was of that could be controlling her in any way, like making her do things against her will. I don't know. It's all going to depend on how it's going to play out in the court. Is my point. But anyway, the judge couldn't decide on this, and he actually pushed back in regards to the attorney. Asked him, these are the cases that you're pleading to Owens. He says, listen, every case that you put in, why you're using battered battered spouse syndrome involved imminent threat and a weapon as to why somebody was shot, why somebody was stabbed, why somebody was pushed off a building. Okay. All of the cases, not one of them were, why did I just go upstairs and go to bed? Okay. And they all involved, as the judge pointed out, imminent threat. Okay. And that is when the bomb was dropped that they're going self defense. Now, when it comes to the battered spouse syndrome for the defense, Mr. Henderson did a lot of speaking, and that audio really, really stunk. But basically, he said it wasn't up to the court to decide whether it was valid because they were going to go for self defense, and that would be up to a jury to decide if there was imminent threat. But you have to prove the situation to file the defense. So I'm very curious to see where Judge Kraynick is going to lay on this. He promised to have it out within a week. And then after going back and forth with the state and with the defense, Mr. Owen, and listening to Mr. Henderson, he said he'd probably have it out by tomorrow. I don't think that he was convinced. I think he wants to be fair, and he wants Sarah to get the defense that she deserves. And she wants to fight and leave it up to a jury on certain things. But the law is pretty clear on how to admit this defense. And that is pretty much their hurdle. Okay. It's really not up to the court to actually decide whether she has it or not. Julie Harper, the psychologist, can give all the affidavits she wants. Okay. That proves corroboration of the situation. It is up to the defense to prove the situation existed, which they haven't. They haven't filed affidavits from those law enforcement agents. They haven't filed the police reports as a motion to support. They didn't include any of that in their actual motion to use this defense. And I think that's what the state is using them against it. Sloppy filing it based on the statute, thinking you can just get away with this. No, you need to do the legwork. You have to prove the situation first before you're allowed to enter it even into court for a jury to hear. And they went so forward to say that Julie Harper cannot testify to the jury until the actual facts of the situation are established beforehand. In other words, you better dot your I's and cross your T's, defense. You're going to have to bring law enforcement in there to testify that he was the issue, not her. Okay. And they will be able to prove that there were incidences, but he's going to have to do that. And they're going to have Sarah file either a narrative affidavit or take the stand to be talking about the issue herself before Julie Harper can even testify to collaborate that she has it. You see what I mean? That's how the law is in regards to Wagner. Hold on, let me see. I do have some stuff on that for you. Here, Wagner case review. For those of you that like to read. I had also previously given the law in Florida in regards to this situation that is good for review. Okay. Here is the defense actually came forward with an amendment to their filing, which they did list the law enforcement officers that they would be bringing forward. Okay, so that kind of put a little bit more light onto where they were coming from it, but it wasn't sufficient enough as far as the state was concerned, because this is the state's first motion to strike. And then afterwards, this is the one they filed this morning that the judge did review in to make sure that he had all the facts. And they're just still not going with it. And they're still, like the judge said, it's basically, he told both the state and the prosecution that it's basically they need to decide. He's got 2 points to decide on. He kind of agrees with the state that he does need to decide if there was sufficient, if there's sufficiency, meaning if it meets all the points of law and requirement of notice in regards to this defense. The time He has no problem. They filed it on the 7th of September, and he's fine with that. But sufficiency isn't just timely filing. One requirement is 30 days before trial, but the rest is regards to the law and the statute. And it kind of has to meet certain criteria. Okay. The other one is whether or not it's applicable to this case based on the evidence provided in regards to Sarah's own words of, it was a good day. We were just playing hide and seek. But what really struck me is that the defense is actually going forward with self-defense. They're going to say Sarah was out of her mind with fear. It was self-defense. She was preserving her life by letting him suffocate in a suitcase. Yeah. It's going to be a fascinating trial. It's going to be a fascinating trial. That's what I have to say about that. Okay, I'm going to bring this down for just a minute and just talk to you a little bit about the oral motions that were put forward. Now, again, there was a lot of whinging about traveling and, my time and, this is like, but hey, I'm not really complaining, but I'm complaining. All of this from Mr. Owen. Okay. When he brings his oral argument forward, it says that, he needs more time to object to the evidence now that he's been turned down for the statement of particulars now and all that. He needs time to go over everything again. And originally that date passed on September 17th, and he has filed no objections to any, including the interview he seems to have an issue with. He didn't even make a preliminary motion to object based on her rights. And this is another one when I went, it is like, what? Here you are. You went out of your way in the beginning of September to tell the state to go find this stuff for you, knowing you want to use it as a violation of her rights during the interview process. You have the video, but you didn't file a motion to try to have it objected to. If you believe, as you just said in court in front of Judge Kraynick, that she was coerced, that she was made to feel intimidated because the officer was wearing a gun. They're officers, they do. Okay. That everything that she said for all of those hours was coerced. She was intimidated. She was led astray. They were leading questions. You could have put all that in a motion. You've had the conversations with Sarah. This is what you intend to file. Where are they? You had until the 17th to do it, but you didn't. You see, this is the problem I had. They know they're under a time constraint, but they want to make it everybody else's problem. It's like, well, I know I should have did it by the 17th. Well, now I'm asking the court, can I have longer? And to the graces of Judge Kraynick, he allowed it. He said, you know what? The evidence that you have is everything that's from file. Granted, there's nothing new. You can have up till pre-conference date of September 26th to file any objections in regards to the evidence the state, who very, very assiduously told you everything that they have and how they're going to use it. In like, you've had it since August. Sarah's had it for 4 years and 20 months through various attorneys, and even her says, pro se, she had it all along. But we'll give you till the 26th to file any motions to object to evidence that's going to be presented. Blah. Okay. But he wanted more. But Judge, I need more time for discovery and witnesses. Every day I could find out something new, and I want to be able to present it. I need more time. And the judge again said, you can have it up till the trial date, because we're not going to go into jeopardy, because the state's only concern was that if the jury starts to get seated and they decide to pull a fast one, they weren't having it. And he also said, depending on what they come forward with, they may file for a continuance. And rightly so, based on information that they bring forward. And the judge said, okay. So currently, we have until October 7th to hear from the defense exactly where they're going with all of this. Okay. But they may not be able to do the defense of battered spouse syndrome, depending on the ruling of Judge Kraynick, which, oh boy, I'm going to be waiting with bated breath for that one. But I got even more to talk about. Let's just leave that here. Sarah has not been a very nice person. Okay. This Tanika 2 cents, she likes to pull those IMS reports, on Sarah. And I'm going to give you a video here just to lighten it up a little bit. Okay. Just to lighten it up a little bit. And also to lighten it up a little bit um in regards to Judge Kraynick, let's just say the additional time, it was granted and not granted. Okay. So in other words, he gave them pre-trial conference date of 9/26. Okay. In order to object to the evidence, okay, that's already been submitted. And then it's going to be case by case allowance or denial as additional evidence, witnesses are discovered by defense up to the date the jury is seated. However, not to conflict with jeopardy. It was very clear. And the state actually said, if it gets anywhere near jeopardy, we're going to contest it. And also, depending on what they bring forward, we may, in all fairness, have to ask for a continuance. And the judge agreed that if they start to throw like monkeys and monkey wrenches into the situation, or come out with left field with something else, there's not going to be a gotcha moment. Okay, the state will be allowed the opportunity to respond. So that was left open, and that's why that's like approved and denied at the same time, a little bit here and a little bit there. The defense actually won an extension in regards to their objection to the existing evidence. That will be till next week, since the time already passed and they didn't do anything. All right. But man, self-defense? Self-defense? Wow. Anyway, Tanika's video goes over the IMS reports over the week, which have stopped, by the way. That says Sarah's had a couple of incidences in regards to not cooperating with the prison staff. And she's quite miffed that, on September 6th, the captain, Di Giovanni, who is actually in charge of the whole prison, actually put out an email that said, Sarah no longer gets a laptop. She has an attorney. And according to the judge's ruling, that was the reason that she had it. It does violate protocol in the prison, and we don't have to do it anymore, and we're not going to. And then she called Judge Kraynick, and they spoke, and he understood, and he agreed. And so a memo was put out, and Sarah doesn't get it anymore. But Sarah, from that week, really was only using it a few hours a day anyway, not using the additional time. She even turned it down once, saying, "Oh, I'm so tired from yesterday working so hard on it. I think I'll just take the day off." Okay. So Sarah's acting a bit smug lately. She also stayed on a phone call during the process at the jail, where the nurse comes in to do medications, and there's a time frame and you have to go up to the cart and get your meds. And some people showed up late, but Sarah stayed on the phone the whole time. And then when they were leaving, went up there and demanded her meds. And actually the actually prison guard at that time said, "I'm sorry, but she's getting ready to leave. You're going to deny me my meds? I'm going to have to report you to the superintendent." Like, you have to listen to Tanika's video. She has the whole thing laid up there. If you're part of my Discord as a member or as a collaborator, I did take some clips from the report itself and put it in the Sarah Boone room for you. Those are from Tanika's. In full transparency, they are actually from the video. Watch the video. You're not going to believe it, but she's actually had quite a few little incidences. But the reports have stopped. The laptop has been turned back over to the defense attorney, Mr. Owens. Okay. And then there was a whole nother thing about Mr. Owens scheduling time in this big room that Sarah always wanted everything to be done in the big room, instead of where the attorneys meet. Okay, usually. And apparently the office was complaining that they couldn't get the visitation that they wanted with Sarah. And Sarah was complaining that she wasn't able to see her attorney. But that wasn't the issue. The prison literally called him to explain the issue. We're not denying you so that you can't see her. We're denying you because you want that big room. And the whole prison uses that big room. We can't always give you the times you want. We can give you any time you want between this time when you use the attorney room. He claimed he was not aware of that situation and that he would comply from now on. And she said that he would make his visitations between 9 and 4. And she then reminded him that that's okay. You can come early if you want, as long as you're in the attorney room. Just let us know. Let us know. But Sarah cannot be in that room when they're doing head counts and this and that. Problem was she wanted to stay late and there were head counts and she gets escorted out. And she was complaining, saying that they were keeping her from her attorney, even though she knows she has to be cleared in the morning for the morning head count, which is standard procedure in the prison, and the evening head count. Okay. She's being unrealistic. Okay. But I have to get the prison credit. They're like, you're not going to throw shade on us like we're doing something wrong that we're not doing. We're putting up with your silly butt as best as we can. And you're going to need to shut it. Because several times in there, they said she earned negative experience activity points. They are not playing with her anymore. They're like, shut it, Sarah. We're on to you. You're not going to make it like we're doing something we're not. And they're addressing it with the judge, with the attorney directly, and right with Sarah directly. It was pretty good. I thought that based on all the Scooby-Doo moments we had in this hearing and the horrible audio that we had to put up with, that Tanika offered a little ray of sunshine with some snark and humor that you might appreciate. So I thought I would share it with you. Okay. Well, the next and probably last thing is our saint, Judge Michael Kraynick. You see that face? He is listening to the argument. This is when they were talking about battered spouse syndrome. And he's listening to Mr. Owens not addressing the questions. And he clearly asks him, what about Wagner? Wagner has been brought up in opposition of what you're claiming, and you're not addressing it. And and Owens wouldn't address it. And Judge Kraynick showed, at least me, in like I'm no expert, but me as a layperson watching this stuff who has a fascination, I watched him actually go over all the points of Wagner. It's obviously that he read the briefs and looked at both arguments and what they were saying and pulled up the evidence. And what he was trying to tell the defense is, I understand you want to use this, but you're not actually following the rules for pleading on it. You're not even giving me any kind of case law to go by that is applicable to this case, sir. This was not during an argument. This was not the use of a gun or stabbing or any weapon whatsoever. This is not during a strenuous situation to where she wasn't thinking. You're not using the protocol for establishing this. He's trying to let him know. And this man is like, he literally just said right to the judge, I haven't researched it enough. I don't have case law prepared for you. I'll have to get back to you on that. And the judge says, well, I'll be making my decision. Indeed, it was after all of that and hearing from Mr. Henderson, who obviously pertains to himself being somebody who uses this self-defense in victims of abuse kind of situation, on battered spouse syndrome, on having some knowledge on it, never brought up case law to defend their position on it or why they should be allowed to not use the actual protocols for pleading it, for filing a motion on it, for actually doing their intent to use it. Why the state is wrong when they say they have not pleaded sufficiently the necessary elements. Neither of them did. And Judge Kraynick really tried to go out of his way to let them know. I'm going to be curious to see how this all plays out at the end, or when he comes up with his ruling on that particular motion. Because if they're not able to use battered spouse syndrome, where are we at? Are we back to an accident? I mean, thankfully, the jury doesn't hear any of this. They could clearly just go that, she was drunk. She didn't know. She didn't mean to do anything. And to actually call this murder too is crazy because, like, they had a good day. I think they should be better off with that. You know, I think they'd be better off using all of the incidences that, like, he didn't tell the truth. He was a liar. He was a bit abusive. So she didn't believe him when she said he couldn't breathe. Doesn't that sound more reasonable? And then it would be up to a jury. But they don't want to take that chance, I guess. They want the jury to feel sorry for her. And that's where I ask the next question. Do you actually think a jury is going to be sympathetic to Sarah Boone? I watched her face several times. They put a camera like to the side, to whatever, even as her attorney was speaking. And she cringes, she makes faces. She's obviously judging his performance. And he has said things that she wouldn't say that way. She doesn't come out very sympathetic. But then again, I would have to admit, after all of this time of covering her hearings and reading her letters in, that might be a bit biased. But what do you guys think? What do you guys think about any of it? Because I'm going to be wrapping up. Who on earth would be upset by the possibility of not being able to have the custodial responsibility for Sarah's welfare? Exactly. Liam, you crack me up. You're cracking me up. Okay. Anyway, I'm gonna remove Mr. Our saint, Judge Michael Kraynick. I can't praise him enough. I can't praise him enough. I'm telling you. Okay. Hey, Cat Ninja. Do we think she will take the stand? If they use this defense, she's gonna have to, from what I'm reading, since she's the only one that can lay out the situation. And that would leave her open to the prosecution's counter. And I just don't think that's going to go very well for her. She is exactly the kind of defendant which will get the jury's backs up. Exactly, especially if she takes the stand. Oh boy. Who on earth would be? Oh, I already read it. Sorry. Cat Ninja, this is like, oh my gosh. I'm telling you, if Juju gets you up to date on this one, like, oh my gosh. Oh my gosh. I bet the employees of that jail are eagerly anticipating Sarah's trial. I'm wondering if they're going to have a lunchtime watch party, like, to tell you the truth. Popcorn and beer. Yes. Hmm. I do agree with you. They putting her on the stand is a huge mistake, especially when they want to go with the jury sympathy, especially when there's no one but her words, and they're going to be able to play that interview. Since it's not been objected to yet, it's not been tossed out. I'm assuming it's going to be there, but we'll see a trial if they get to play that interview where she says they had a good day, everything was fine, it was an accident, they're in a loving position now, everything's been going great. How are they going to believe all the other stuff? What they're going to believe is that she's crazy, is what they're going to believe. If it was me, if I was the jury, I would be like, well, okay, I believe that she got something wrong in the head, but was there imminent threat here? No. So self-defense, I mean, proving self-defense without imminent threat is really difficult. And it is one of the reasons, to be honest, proving imminent threat for self-defense without something like that happening immediately is why battered spouse syndrome and the laws around it was created as a defense, to prove that a long-term history of abuse could change the way somebody thinks, and they alter their sense of reality when it comes to what was a threat and not. But there are no cases of precedent which show somebody locked up during a game of hide and seek in a suitcase, which he had to get in, and she zipped up. Okay. And we heard no threats from him on that video. It appears that Sarah was the threat when you played the video from her phone. To me, he was just, you know, she could have even opened it a little so he could get out himself. She could have left. She could have, if he could, he said he couldn't breathe. She could have called 911 and went to Brian Boone's house, which she has done in the past, when she said she needed a break from the situation. Brian did give testimony to that, like, not testimony, but he did give a statement on that. Yeah. Using that defense is frankly rude. I think so. And I think when he that could be how the jury looks at it. Like, you got some nerve. I heard the video of him pleading for his life. I don't care if he does call you names and makes you feel bad. There's many things that you could have done. The charge is about disregard, and that there were things that she could have done that could have prevented the death of George Torres, and she didn't do them. That's the charge. Not that she actually physically laid hands on him and killed him, but that she had the ability to change the outcome and didn't do a damn thing. Well, one of them made it out alive, so our assessment that Sarah was the threat feels accurate. Yes. And I'm not laughing, because the thought that this man died in that way is horrific. Horrific. Okay. He could have been a bad person drinking. He may have hit her. But I do believe, reading a police report, at least one of them, where Sarah was the one charged as the aggressor for strangling him, and that his actual physical on her was in self defense, kicking her off of him. And that Sarah had to admit to the police that that is what had happened when they actually talked to her about the injuries. So, Sarah actually defending the situations of the police reports is going to be really something if she does take the stand. I think the state is hoping she does, because I think that they're ready. I really do think they're ready to counter these. I think that they are offended about this attorney coming in with this late defense, but rightly so. Sarah deserves attorneys, and Sarah does deserve good defense. And if they want to throw anything they can at the wall to try to get it to stick, great. And I'm sure Sarah was so pleased when they listened to her and decided to go with this, because it's my humble opinion that that's why Mauricio Padillo left. Oh, because he did have an expert and he was looking into it and he didn't use it. I think he rightly told Sarah, you would have to actually talk about it. And Sarah talking out of both sides of her mouth, so to speak, will be the issue. You can't have it on file one way and then claim it was something else. It's going to look contrarian and they're going to use it against you. And I think that's what the attorneys were advising her. It's not going to play. You're going to come off bad. We really need to do something else. There is no imminent threat. I know the law. There is no threat there. How do we do self-defense? You didn't do anything to him. You told the police it was an accident. How is an accident? So it's accidental self-defense? Is that a new term? Anyway, I think I'm going to leave it there. They clearly didn't treat each other with respect. Absolutely, they don't. It was way too physical. It was definitely abusive. These two, whatever the relationship, it was not good for either one of them at different periods of time. If Sarah takes the stand, the prosecutors only need one, maybe two questions, and she will sink herself even farther than she already has, probably. Thankfully, for Sarah, the jury has not seen anything that she has said, nor the letters. I wonder if the letters will come in. What do you guys think about that? Do you think all of her letters, since they are part of the court documentation, do you think they'll come in? If Sarah decides to take the stand. I don't think they will, because there's too much in there about stuff that won't be coming as an evidence, I accidentally self-defended myself. Exactly. During a game of hide and seek. Like adults do. play hide and seek in like they tell you where they're gonna hide, zip themselves into a suitcase right in front of you. Mm. Yeah, the whole thing is ridiculous, and I don't know. I at this point I'm kind of feeling for the state. I know they want to be done with it. And to be honest, I actually think that Mr. Owens wants to be done with it as after today too. Um, and just we're gonna have to leave it there and see what happens with Judge Kraynick's ruling. But y'all know how to reach me. You do, and you know what? I forgot the banner today. Let me just put it on for a minute. Like at least there's some banner show up because I do like when you like, subscribe, and I really do like when you comment on the back of the videos. I do like talking to you all about it. If you have anything more to say, especially after you look at some of the stuff that I sent you, regards to especially battered spouse syndrome and how this could possibly even apply in this case. I'm not saying that it wasn't an abusive relationship. Even the state says it was. But the state also clearly stated in the hearing that that would also bring her part of it up, her alcoholism, her statements from her husband in regards to it. Um, yeah, they're trying to let you know that maybe it's not going to go the way you think. And you know what? Sarah sat there and she heard it all. She heard it all. Anybody think there might be another letter coming our way? Do you think maybe she's going to ask the library to Google law how she could get rid of a lawyer that she never even hired for like free? Like, can you get rid of a pro bono attorney? Like, I don't know. Poach. Oh my goodness. I know. I just had to. Sarah heard it all, but did she hear it? Good question, Juju. I'm with you. I doubt it. I doubt it. True. A good defense. That's all. You know what? That's all the state attorney has to do. The prosecution, all they have to do is like, what happened, Sarah? In your own words, tell us what happened that night. And just let her talk, just like they did in the interview, right? Yeah, exactly. Exactly, Cat Ninja. They had a good day. It was adult hide and seek. It's just, yep. hmm I don't know what she was thinking. But anyway, guys, thank you so much for being here on a different day at a different time with this case again. Hopefully, I will see you all tomorrow. I'm going to try to put together a what the F. We'll see how that goes. As you can hear, my voice is already on its way out. I'm just going to go rest it for a little bit. And hopefully, if our lovely bee has got her buzz back, perhaps we will be here on Sunday too. But besides all that, if you're here for the true crime, we will definitely be doing some true crime on Tuesday and Wednesday. You know, you like that one? My little bee getting her buzz back. Yes, yes, because we need you energized and full of buzz for the show. Hey, yeah, she just, I agree with both you and Jin though, Juju. The Sarah hears everything. She just, I mean, she's listening. She hears everything. She just doesn't acknowledge it. She just like just gets rid of it immediately because it doesn't go along with what she's thinking. You know. Well, on that, guys, I am heading out. Have a good night. I'll talk to you all soon. Don't forget, like, share, subscribe. Don't forget to call me on the back of the videos. See you later.